Okay, so you've helped a client form their company and get investment. And they use that investment to retain talented people to contribute to the growth of the startup. What do those people produce? What usually comes next for us attorneys to help our client with? Well, when we hire talented people to work with startups, we're not hiring them necessarily to build physical products. We're not hiring them to go dig up minerals from a mountain. They're actually coming up with intangible things. So they're coming up with ideas, they're coming up with concepts, they're developing new ways of doing things. Maybe they're actually building some products. So it could be in design, they're designing a product, not building it, but designing it. So it could be a internet product, like an app for a phone or a website. Could be a cryptocurrency. It could be some new strain of marijuana. It could be pharmaceutical. Who knows what it is? But the startup's initial stages, at least, if not until it exits, is to come up with new innovative ideas. Because remember, that's what a startup is. They're seeking hypergrowth through innovation. So how that impacts the law is our job as an attorney is to protect and capture as much of those intellectual assets that are being created and developed by our talent in some protectable form. So this is what we generally call intellectual property, although there's no thing specifically that is intellectual property. Intellectual property is made up of four different things, which I generally call the four horsemen of IP, or the four legs of the IP table. And you need to think about all four of these things together and in conjunction with one another. Okay, so this is what I was just talking about. So you have people that are doing work with a startup or for a startup. They have ideas. And then those ideas, it's our job to protect those ideas through the law in some way. And once we've protected the idea, then it becomes an asset. If someone works for a startup and they have an idea and they release it to the world and nothing is done to protect it, then anybody can use that same idea. And it's not an asset. There's no exclusive rights in it. There's no ownership of it. And so the startup has funded, by hiring this person and paying their compensation, has funded the development of this idea and released it, but now hasn't captured any assets. So it's our job as attorneys to do everything we can to protect the ideas and the intellectual work of the talent involved in the startup and convert that into protectable assets. Okay, so I generally go over the four types of intellectual property in the chronological order that they are generally created. So a trade secret is the first type of intellectual property that gets created. Okay, and the definition of a trade secret is information that is not generally known and has value. Okay, so it has to be some valuable information that's not generally known, and it has to be a subject of efforts to protect its confidentiality. Okay, so you spend time and money coming up with a good idea, a new recipe, a new whatever, a new business idea, a new way of accomplishing some business idea that has value because you think it's better, faster, cheaper than what's already out there in the marketplace. But if you just tell people, well, now you've not done anything to protect its confidentiality, so you don't have a trade secret. So you have to subject it to efforts to protect its confidentiality. What does this generally mean? Well, in the old days, it meant keeping important documents in filing cabinets with keys. I don't know if you've been around any old style filing cabinets that actually have keys to lock the drawers. That's the old school example. Limiting portions of a company's offices to only the people that are relevant. So let's say all the financial data about a business should be kept in one part of the office building where only the financial people are allowed to access. All the engineering information should be kept somewhere else. So the accounting people should know nothing about the engineering trade secrets. The engineering people should know nothing about the accounting secrets. The sales people should be another siloed organization. So keeping information limited to just the people who need to know it. Nowadays, in the modern era, that means limiting who can access documents on the internal disk drives of the company. So not allowing the engineers to find the accounting documents on the document system of the company, having passwords to protect things, not oversharing information. Before you give it to any person outside of the organization, asking them to sign a confidentiality agreement. So I'm going to put here technological means, legal means, i.e. so like a non-disclosure agreement, confidentiality agreement. Okay. Until a few years ago, trade secret was solely state law. So in the past was solely state law, but then under Obama, we have the Defend Trade Secrets Act. So we actually had a federal law passed just within the past few years called the Defend Trade Secrets Act, which made trade secret protection also a federal right. So it's not just a state right that's violated. If somebody violates your trade secrets, it can also be a federal right. Now, it's not exclusively federal. Like we'll talk about some of the other forms of IP. It's both state and federal. And a quick trivia question that's pretty interesting. The first lawsuit brought under the DTSA was actually brought here in Miami Beach, in the Southern District of Florida. Okay, so that's the first type of IP that your business is going to create. So valuable trade secret information that people don't generally think about first is like a list of all your vendors, like people who are selling you stuff, how much they're selling it to you for, a list of all your customers, obviously. So sometimes when people leave law firms, they like to take the list of all the law firm clients. Well, that's a trade secret of the law firm. You know, who their clients are, how much those clients pay, their contact information. That's all information that's not generally known, and it has value, and the law firm, we can assume, is subjecting it to efforts to keep it confidential. So you can't just go take all the information about who the current clients are. And people do this all the time. They take, like a salesperson works for a certain company, and they think that when they leave that company, they can take all those contacts with them. Financial institutions, banks protect all that kind of customer and vendor information very strictly. Okay. The next form of intellectual property that generally gets created is copyrights. Okay. Okay, so the copyright is an original work of authorship that is fixed in a tangible medium of expression. So an original work of authorship fixed in a tangible medium of expression. So if I was to recite some poetry and just, create it in my mind and say it out loud, that is not copyrightable, because although it's an original work of authorship that I've created, it's not fixed in a tangible medium. If I write my poem down on a piece of paper, or I type it into a computer and save it as a file, now that's a copyrightable expression. Let's go back to trade secret real quick. No requirement to register. Okay, so you don't have to register your trade secrets. You don't have to, there's no federal trade or state trade secret office that you have to say, this is my trade secret, I want protection of. Copyrights. So created instantly. Okay, so as soon as you fix an original work of authorship in a tangible medium, so if you paint something, if you design a website, as soon as you fixed it in that tangible medium, you have a copyright instantly. Okay, so it's created instantly, but must register before filing. Okay, but before you can sue someone for infringing your copyright, you have to register it with the Copyright Office. Okay, so let's put in here, this is exclusively federal law, not state law at all. So under the Constitution, Article 1, Section 8, it says the exclusive right to grant copyrights and patents is for the Congress, federal law. So there is no such thing as state copyright law. All copyright law is federal. And there's a Copyright Office with whom you can register your copyrights before, and you have to do this before filing suit. There was a recent Supreme Court case where some courts had said you could file a lawsuit, and if at the same time you applied to register your copyrights, that'd be okay. The Supreme Court took that and said, no, you have to actually not just apply to register your copyright, it has to be registered by the Copyright Office. That requires paying some fee. They have to make sure that you did everything correctly. It's not that rigorous of a process, but it's something that has to be done before you can file a lawsuit. Infringement is any copying, modifying, distributing, or performing. Okay, so you infringe someone's copyright if you copy the copyrighted thing, you modify it in some way, you distribute it, or you perform it. So perform would be like, think of songs or movies. Like I may not be copying your movie, I may not be distributing it, but if I play your music in my restaurant without your permission, that's an unlawful public performance. Okay, let's go back to trade secrets. So infringement is any unpermitted use. Okay, so is any unpermitted copying, modifying, distributing, or performing. Now, a lot of people, know already, because I'm sure you've heard about it, there's some exceptions or defenses like fair use, but there are some defenses like fair use. This is the Robin Thicke song with Pharrell Williams, where they were accused of infringing the Marvin Gaye copyright, whether or not their song had a little bit of the same riff and was therefore derivative work, etc. Okay. Let's see. Remedies are damages plus injunction. Okay, so if someone infringes your copyright, what can you get? You can get damages plus an injunction to prohibit them from continuing to infringe. Same for and that's generally speaking. There's some more specifics. If your copyright is registered before the infringement begins, you can actually get what are called statutory damages, which is a minimum guaranteed damages, even if your actual harm doesn't reach that amount. Okay, so that's copyright. So startups can have all sorts of copyrights. Largely the software that they write for their app, their computer program, their website is copyrightable. There was a debate about whether or not software was copyrightable because some argued that software wasn't an original work of authorship, that software is very mechanical and it's not creative, and copyrights are meant to protect creative things. But the people that were anointed to make this ultimate decision said, well, there's lots of different ways to write software and there is enough creativity to satisfy the originalness requirement of copyright law. Okay. After copyrights, then we have trademarks, okay? The trademark is any indication of the source of goods, services, okay? Can be visual or other sense. Okay, generally, these are visual things, like the check mark for Nike, the big golden arches for McDonald's. It's something that when you see it, you recognize in your mind the company that's behind that products. Okay, so trademarks cannot be generic. Okay, so if you want to sell cars, you cannot have the trademark cars to sell cars, okay? Just like if you want to sell apples, you can't have the trademark Apple to sell apples. But you can have the word Apple to sell computers or phones because the product being sold is not an Apple, okay? So that would be generic if you were using the actual word to sell the product that is defined by that word. So if you wanted to use the word Apple to sell apples, you can't do that. You cannot have a trademark right. You can't have exclusive rights over the generic description of the product you're selling. But you can have trademark rights over an arbitrary use. So like the word Amazon to sell products online. That's the word Amazon is a known word. It means a river, a famous large river. But that has nothing to do with selling things online. So you can use Amazon to sell stuff online. You can use Apple to sell computers and phones. So this is a pretty good video about this point from the lawyers at the Velcro company.
We're a company that's so successful that everywhere you go, you see the scratchy, hairy fastener, and you say,
"Hey, that's Velcro!"
But even though we invented this stuff, our patent lapsed 40 years ago. Now no matter who else makes it,
you still wanna call it Velcro.
You think it's awesome for us, we're famous, but we're lawyers and it's causing us grief. Cause there are trademark laws being broken. It's all here in this short legal brief.
And we know that this is confusing because Velcro brand is who we are.
What if you call it all Velcro?
We're gonna lose our circle line.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
We know this seems ridiculous. This is a first world situation.
And we made $500 million last year.
I went to Turks on my last vacation.
And we're asking you not to say her name. We took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah!
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with If you have blood from a boo-boo you made, this is a bandage and not a If you're exercising with someone you're dating, it's in life skating and not I know that bleach stuff is more fun to say, but if you keep doing it, our trademarks go away.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
Okay, so the point they're making in the video is that even if originally your trademark is not generic, if people start using it generically, you can actually lose your rights. So they have the examples there like rollerblading and Band-Aid and Clorox. Like, you can't use those. Those are the brand names of inline skating and bandages and bleach, right? So it's not Velcro, it's hook and loop fastener. And this video actually was so popular, they've made a second video, which if you have the time to watch it, it's pretty tongue-in-cheek. Funny. So it cannot be generic, okay? Can be lost if goes generic. Okay. Another, we divide up trademarks into basically 5 categories. So there's generic, descriptive, suggestive, arbitrary, and fanciful, okay? Category, let's do that here. Categories, generic, descriptive, suggestive, arbitrary, and fanciful. Okay, so we've already gone over, and this is the range of strength. So the strongest kind of trademark is fanciful, the weakest or non-existent trademark is generic. Okay, so fanciful would be coming up with a brand new word that doesn't exist, like Xerox. You know, that word doesn't exist in the English language, it's a brand new word. That's a totally fanciful mark, that's the strongest kind. Now notice, the downside to a startup is that if you come up with a fanciful mark, no one's gonna know what you're selling. Right? So if you were to say, hey, I'm a startup, we're called Xerox, no one's gonna have any idea what you're selling. So you're going to take a lot of time and effort and advertising to convince people or train people or educate people about what it is that Xerox is. What is Xerox, right? It'd be much easier to say photocopy company, right? Because then everybody would be like, oh, I know what a photocopy company is, but that's the weakest kind of trademarks, okay? So because of that, a lot of businesses don't like to adopt fanciful trademarks. They're difficult. Arbitrary is like Apple and Amazon, which are, you use words that are already in the dictionary and you just use them for a different kind of product or service. So like Tesla, to sell cars, right? Tesla, the name of a scientist, you know, that's a known word. And it's used for an arbitrary purpose to sell cars. Like if you asked 100 people, there's a company named Tesla, what do they sell? They would have no idea it sold cars, except now they know Tesla sells cars. Okay, so that's also very strong. So arbitrary and fanciful are very strong marks. Suggestive is where you use a word, as it says, like that kind of suggests but doesn't necessarily tell you. So if you were to say, I have a company called Time Saver, right? Time Saver. And what it does is it's an online to-do list manager, right? So if I was to ask other people, there's a company called Time Saver. That's what they're called. What is it that they do? You'd still have no idea, but an online to-do list, that's kind of suggestive. That's not really arbitrary. To say an online to-do list saves you time, that's kind of suggestive. Okay, it's not arbitrary. It's not generic. So it's somewhere in the middle. And then between suggestive and generic would be descriptive. So let's say if I wanted to sell cars, and instead of using the word car to sell cars would be generic. If I said four-wheeled transportation device, that's the mark I want to use, four-wheel transportation device. Well, that's descriptive, right? I'm describing what it is I'm selling. So descriptive marks are considered very weak. You cannot have exclusive rights over a descriptive mark unless you've used it successfully in commerce for like 5 years and can prove that people are actually identifying you as the source of those goods. So as lawyers, we always tell clients, look, if you want to use a generic name in commerce, you can. There's no law against it, but you're not going to have any exclusive rights. And so your arch enemy competitor could start using the same mark. You can't stop them because you can't have exclusive rights over anything that's generic. Descriptive, also, we have to advise clients against descriptiveness because those are very weak marks and they're difficult to protect. Suggestive is usually the sweet spot where most clients end up. They end up with something suggestive because that doesn't require a lot of money to educate the marketplace on what it is they sell. But as a lawyer, we would say the best are arbitrary or fanciful marks. Those are the best. Okay. And infringement is any unauthorized use or a famous tarnishment. Okay. Exceptions, criticism. Okay. So if someone uses your trademark, I'm not sure that's right. Criticism. If someone uses your trademark without your permission, then in a way that confuses consumer, So you have to, the ultimate test to prove trademark infringement is consumer confusion. Consumers are being confused. They're buying someone else's product, thinking it's mine because that other person is using my mark or a mark that's substantially similar to my mark. Another way to infringe a mark is if it's a famous mark like Disney or Google. Even let's say somebody wanted to use the Disney mark to sell cars. Now Disney doesn't sell cars. They have theme parks, they make movies, they have toys, but they don't sell cars. So you would say, well, someone else can use the word Disney to sell cars. But because Disney's so famous, a consumer would think that Disney selling cars is the same Disney that has the theme parks. Okay, so this brings us to another point. If the mark is not famous, if it's not famous, and how do we determine what's famous or not? I advise you to take trademark law. I'm not going to go into that. If not famous, limited to goods and services used with mark. Okay, so if I have the mark Velcro for a hook and loop fastener, and Velcro is not considered famous, someone else can use Velcro to sell pizza or cars or an online app, something that's a totally different good or service than hook and loop fastener. Okay, so your trademark rights only extend to the goods or services with which you're using the mark. This is why there can be the Jaguar football team, the Jaguar automobile, and there's also software called Jaguar. They're all three owned by different companies, all using the same trademark, but they're completely different products or services. None of them are considered famous enough to be able to preclude other people from using the same mark, even for different products or services. And like with copyright law, that there's an exception for fair use, there's a similar kind of fair use for trademarks where you can criticize companies. So for example, there's a whole rash of websites like Walmart sucks, Target sucks, Procter & Gamble sucks. And these companies tried to sue to get those websites taken down, saying that's an unauthorized use of our trademark. The court said, no, it's clear that they're not trying to sell a product or service by pawning off their own product as yours. They're actually criticizing you. And so that was protected under First Amendment principles. Okay, the fourth and final type of IP. Oh, let's go back to trademarks, both state and federal. So trademarks are creatures of both state and federal law. You can have trademark rights under state law and trademark rights under federal law. No requirement to register, but benefit. Okay. You also get trademark rights once you start using the mark in commerce. So once you start using the mark in commerce, you have rights to that trademark for any subsequent user. With the exception if someone has applied to the trademark office to use that mark before you started using it, and they start using it eventually within the period of time they're permitted, then they have prior rights because they applied to use it before you started using it. This is why, although it's not required to register trademarks with the federal government, attorneys usually advise that that's a smart thing to do, so that way someone else can't preempt you. Say if you know you want to launch a clothing line with Dan Ravisher as the brand name, or Kim Kardashian, or whatever. Well, you haven't gotten all your ducks in a row to actually build the apparel and the website. So you could wait until you have your website up and operational, and then you have trademark rights when you start using it. But if someone else starts using it first, you could lose those rights. So rather than taking that risk, once you have the idea you want to use Kim Kardashian to sell apparel, you could file a trademark application right now under what we call an intent to use. And then if the trademark examiner approves it, then you have a certain period of time, up to 3 years, to start actually using it. And if you start using it within that 3 years, then you have priority rights over anyone else that started using Kim Kardashian subsequently. Okay. Patents are exclusive, like copyright, are exclusively federal. So there's no such thing as state patent law. Okay, must be a new, useful, and not non-obvious invention. Okay, so patents don't cover just ideas. It has to be an invention, and there's a difference between an idea and an invention. An idea is, I want to cure cancer. Okay, that's a great idea. An invention is actually coming up with a real cure, like use this chemical, use orange juice with some milk and sprinkle some salt on top, and that'll cure cancer. Okay, so you have to actually come up with an invention, not just an idea. And it has to be both new, has to be new, useful, and not obvious in light of the prior art. No rights until granted by USPTO. Okay. Now, unlike the other three forms of IP that come into existence when you create them, when you create a trade secret, you have rights. When you fix a copyright in a tangible medium, you have rights. When you start using a trademark, you have rights. Patents are the one that's different. You don't have any rights until the federal government grants you a patent. So you have to apply and then deal with any issues the examiner may have in reviewing your application. And then if and when you get granted a patent, that's when you have rights. So you don't have any rights until your patent is granted. Now, for copyrights, you have to register your copyright in order to be able to sue, and you do get some enhanced powers from registration, but it's not required to have a right per se. Same with trademarks. You register, you get enhanced benefits. You don't have to register your trademarks to sue because you can file a state court action, even a federal court action without registering, but it's preferred to always register. Okay. And infringement. Any unauthorized making, using, selling. So anyone who makes, uses, or sells something covered by your patent without your permission infringes your patent. Remedies, damages, injunction. In all these forms, you can also apply to get attorney's fees. And copyright law, if you've registered your copyright in advance, you can be presumed to be entitled to your attorney's fees. Again, I'm not going to go into each of these separately. We teach patent law here. We teach trademarks and trademarks too. We teach copyright law. I think there's a trade secret class as well, where it's combined with IP for business lawyers. So if you're interested in IP, go take more of these courses. This is a good summary chart. It's a little bit outdated. So for example, trade secrets, trade secrets, I don't think it says that it's, federal and state law protects it, okay? So this is a good summary. Trade secrets, copyrights, trademarks, and patents laid out in exactly the same way. And it gives you an overview of what they are, some requirements, how they're protected, and how long they last. Okay. One of the most important things to do when you work for a startup is to make sure the startup owns the intellectual property. This is what we do through an agreement called a Confidential Information and Invention Assignment Agreement, or CIIA, something along the same sorts. You might be surprised to know that under most intellectual property laws, the employer or the service recipient in a services contract is not by default the owner of any intellectual property created as a result of that engagement. So to resolve any of those disputes, there's actually a whole Supreme Court case about this involving Stanford University. There should be an agreement between every startup or every company and every person doing any kind of work for it, even if they're just an accounting person or a salesperson, marketing person, definitely your engineers and your designers, that says any and all intellectual property that they create through their service to the startup is owned by the startup. So they also agree to keep all confidential information confidential. That protects the trade secrets. Any copyrights they create, any trademarks they develop, any patents or inventions they come up with are all owned by the company. This is one of the biggest issues in which startups go wrong, is they don't have these agreements in place. You might remember from Module 1, the due diligence checklist actually asked to see these agreements, these confidential information or non-disclosure agreements and invention assignment agreements or intellectual property assignment agreements between each key person, if not all individuals who work for the business, and the business. You have to make sure that you have those agreements in place so that the startup owns the asset. It does no good to apply for and receive a patent in the name of one of the engineers if the company doesn't own it. This is actually something I've had to fix in my own legal career, where the startup didn't actually own all the IP because they hadn't gotten an agreement in place between all of the individuals who were doing work for the startup that said any IP they develop gets owned by the startup.